It is time for Dying to Bloom with your host, Carrie Potter.
Good morning and welcome to Dying to Bloom. One of the purposes of this show is to encourage thinking about end-of-life issues to help alleviate the fear and make more informed decisions. I also like to raise awareness of how our burial choices impact the environment, ultimately for our children and their children. Obviously, a lot of people say, who cares once I'm gone? But we have our children and descendants to think about. I promote green burial and the Green Burial Fund, which you can find through the Rockland Community Foundation to help bring a green cemetery to the Rockland County area. And we bring into question, does our current practices make sense? I often talk about embalming, and just to give an idea of what I mean as far as embalming goes, you know, I made my kids lunch this morning for school, and I put their sandwich in a nice plastic baggie, and, you know, it made me think for a minute, what if I put that plastic bag with the sandwich in it in the ground and buried it? And pulled it out in a couple of years, what would I see in the bag? Versus if I just put the sandwich in the ground, it would actually, decompose and nourish the earth. Those vitamins and components that make up the sandwich would actually go and help plant life to grow. So, also, as far as embalming goes, you know, if that's something that somebody's really determined to do, there are more green options as far as that is concerned, and perhaps we could discuss that on a future show. But there are embalming fluids that don't contain formaldehyde. But today we're going to go in a different direction. We have here in the studio with us attorney Duncan Lee, co-host of The Law on You. Good morning, Duncan.
Good morning, Carrie. It's good to be here.
Thanks for joining me on this unique show. Duncan's like, what is this show about here?
I can't wait. But by the way, that sandwich might stay around for a long time if it's a white enriched flour, because it's often preserved with BHT, which is a kissing cousin to formaldehyde. So
there we go. Well, anyway, Duncan, April 16th happens to be National Healthcare Decisions Day, and that's a day to inspire, educate, and empower public and providers about the importance of advanced care planning. And that's what I invited you here to talk about today. Advanced directives, wills, that type of thing. If anyone does have a question as we go along, the call-in number is 845-362-0013. But Duncan, I wanted to just open it up by asking listeners to consider, what would you do? Or imagine for a moment you're in a hospital. You can't speak. Soon you won't be able to swallow or breathe. Who's going to speak for you?
Well, that's a very good question. And, you know, you're talking about one of the last great taboo. The 60s was the sexual revolution, and now we're just at the beginnings of the death revolution, where people start giving serious contemplation. When I was a kid growing up, I remember talking to my mother. We were going to see a relative, and it had to be postponed because she was getting her will signed. My mother said, "That's not good." I said, "Why?" She said, "Because Italians only get their wills signed when they're going to the hospital or going on a trip." So it was pretty much true. They were always worried about dying in these places. But most people put that decision off for a very, very long time. The theory still being, once you make out your will, you're going to die. So we've got to get over that taboo. So many young people, including young attorneys, by the way, don't have wills, and they don't have any instructions such as powers of attorney, springing powers of attorney, healthcare proxies, advanced healthcare directives in place. Sometimes the wake-up call for younger people is when they first have children, because now they're thinking, oh my God, what happens if we die in a car wreck? Mm-hmm. Who's going to take care of our child? The concept of your question of, you know, what if you're in the hospital and you're in that coma, who's going to make decisions for you, is something that thank God hospitals step in for these days. You can't check into a hospital without being asked to sign a healthcare proxy form. so that someone will make decisions. And traditionally, even without one, doctors will consult relatives before making a decision. But if you want your wishes followed, whatever they may be, you need to put it in writing in advance in a proper legal form. I always recommend to people who are getting into the estate planning mode, and you have to understand, most of my clients are not multimillionaires. They're typical Rockland people. The biggest asset they own is their homes, maybe a vacation home or a timeshare somewhere, a couple of cars. They've got a pension, life insurance policies, a bank account, and maybe a 401k sitting somewhere. And the question is, all right, how do we deal with all this? And the first thing I tell people you need to think of is people you want to represent you. Who's going to step in your shoes when you need someone? Sometimes it'll be, and most commonly, it's the spouse and the children. And what people are always worried about is being equal with children. So they'll often say, well, we want our 3 sons to be co-executors. Always a bad idea. Co-anything means twice as much legal work and twice as much charging to the estate. So you don't want that. But let's back up a little bit. What should a good plan involve? Well, at least 2 things. One is plans for when you are incapacitated but still alive, and the other is the plans for what happens after you die. Now, the plans for incapacitation usually are divided into 2 hunks. And one hunk is dealing with your finances, and the other hunk is dealing with you, with your personal needs. The hunk that deals with finances is the power of attorney. And what I will often recommend to my clients is that they get a springing power of attorney. This is a power of attorney that will not take effect until some stated condition occurs. And the usual condition is the family doctor, some doctor, any doctor licensed in the state, you can word it many different ways, says that you are unable to make your own decisions regarding finances. And the doctor signs off on that periodically because you want it reviewed to make sure the condition still exists. This power of attorney would then spring into existence, and the person you've named as your attorney in fact is what the person is called, as opposed to an attorney at law. Your representative will then be able to deal with your finances in any way you've described. You can limit it to just one type of thing, pay my bills. You can make it everything, except for one thing. The New York State power of attorney, or any one you draw up yourself, won't meet the IRS requirements. They have a special power of attorney you've also got to get, which you can download from their website and print it out. Now, the power of attorney thus takes care of finances, and the springing power of attorney is one where within the body of the power of attorney it states when that comes into existence. And you, of course, if you regain consciousness and the doctor thinks you've got all your marbles at that point, can say, I revoke that power of attorney. You can do that orally. Of course, it's best done in writing, but you can do that. You may have a problem with, Junior out at the bank as you are waking up and saying you revoke it, taking out all the money. But there are some problems with it. But that's certainly one way to deal with it. The other part of it is the healthcare proxy or advanced healthcare directive. The advanced healthcare directive is a combination of a living will and a healthcare proxy. And what this is instructions on how you're to be cared for while you're alive. And the most common thing that people will want it, because there are all kinds of decisions you'll get hit with when you go visit your attorney about these. One is, for example, do you want to be put on ventilation? Do you want to have your heart jump started if it stops? Do you want drugs to alleviate pain? Do you want feeding tubes put in you? Or you can simply, what most people do is leave it up to my healthcare proxy. The healthcare proxy will, one of the instructions you can put in is consult my other relatives, my other children, my spouse, whatever, and then go ahead, you make the decision. You know what I want. So that's one thing you can do if you have somebody you trust like that. Now, have you seen the movie The Bad Seed?
No.
Oh, that's probably a good thing. In that old movie, this grandma tells her granddaughter, who's admiring her necklace, that it will be hers when she dies. Next thing we see Granny in her wheelchair going down the stairs. So you got to be careful who you choose, and you can in New York State you can appoint a monitor for your power of attorney or healthcare proxy, someone else who will check to see that the person you've named is doing the job. So you can do those things.
Would this monitor be someone you know who,
Well, yes.
I obviously would have to know your health conditions if something does happen to you. Otherwise, how would they even be aware to check up?
You can set up any system you'd like, and there's no such thing as a 100% foolproof system. There are fools out there who can get by anything. But you simply want to act reasonably and reduce the chances of bad things happening. I know you're big on green funerals. By the way, I do have a funeral story to tell you. When I taught chemistry at Nyack High School, I would often take my classes on trips to chemistry-related occupations. And for many years, I took kids to the local funeral parlor. And the first year I did it, I had a young
field trip.
Yes, it was a field trip. It was a chemistry-related activity. In one case, one of my female students started dating the young intern who was there. But I had a conversation with her. I said, "What happens when you go into a bar and you're having a drink and the conversation comes around to what you do for a living? What kind of reactions do you get?" He said, "Well, people do one of either two things. They say, look at their watches and say, oh, gotta go." Or they get real interested. So one of my girls apparently got real interested and started dating this young man. I don't know what happened to that. But another one of my students came to me afterward and said, I've been offered a job at a local funeral parlor, Hanneman's Funeral Parlor. And he said, Mr. Hanneman wants me to help him carry bodies. Well, Keith Taylor was that young man. He now owns Hanneman's Funeral Parlor.
Wow.
And every time he sees me, he kind of rubs his hands together in anticipation.
Oh. No.
I mean, after all, they're the only people in the world who, when you ask how business is and they say dead, they're smiling. So that was my funeral story. But and speaking of, with your green funerals, you once asked me how you could assure that your instructions were followed, and you asked, should you put that in your will? The answer is no. I mean, you can put it in your will, but the problem is most people's wills don't get read for months after they're dead, and by then, whatever's going to happen will have happened. So the safest place is along with a healthcare proxy or living will or advanced healthcare directive, which combines the two, is to include funeral instructions. And my suggestion to make sure they're carried out is what's known as an in terrorem clause. It literally means to be in terror of. And they're usually inserted in wills to keep people from challenging the will. So, for example, you have 3 children, one of whom is turned into an ingrate in your old age and doesn't visit you in the nursing home, and the other 2 are pampering you every day, and you want to cut the ingrate out of your will. My usual recommendation is don't do it. Instead, leave the ingrate enough money so that it's clear that the person is not forgotten unintentionally, and at the same time put a clause in that says if you challenge this will, you get nothing if you lose the challenge. That's the usual use of an in terrorem clause, but there's no reason you can put a similar clause in for burial instructions. So you could have a set of burial instructions saying, here's what I want done with my body. Go see the Hells Angels, get a can of gasoline to match, or bury me in a green cemetery, or embalm me, or leave me frozen like Walt Disney, and I'm leaving you money in my will, and if you don't follow these instructions, you won't get a dime. So that kind of clause could help ensure that whatever you want done will be done. Of course, you have to make sure that the person who's to carry out these instructions has a copy of them well in advance.
That's just what I was going to ask you. Who will enforce that once I'm gone?
Well, if, again, a lot depends on, as the gal said in A Streetcar Named Desire, the kindness of strangers. Mm-hmm. You will have to pick someone that you trust. That's the problem with a trust as well. A trust is often used as a substitute for a will, although they're not my favorite vehicles for the average person. But whether you're dealing with a trust, a will, a power of attorney, healthcare proxy, a living will, you still have to have someone you trust. The problem I encounter, especially with very elderly people, and I mean older than I am a lot, is, sometimes they've outlived all their relatives and friends, and there is no one. Well, you can have a bank. Banks often have trust departments. You can have the bank appointed as the trustee of the trust. You can have your lawyer, although it's generally not a good idea to have the lawyer who draws up things be the lawyer who's going to supervise. In fact, there's some very specific provisions in law about lawyers who serve as executors and trustees of trusts they set up. It's generally, every once in a while, lawyers can do it, but they probably shouldn't. I've had many, many people ask me to serve as their executors or trustees, and generally the answer is no, I don't want it, because it always looks suspicious if I'm the one drawing up the will. And you definitely can't leave your attorney who's drawing up your will any money in that will. That'll get the attorney disbarred and all kinds of evil things, because there's too much potential for undue influence there. So your first order of business for any of these things is, who are you going to trust? Who are you going to call? It's not Ghostbusters. It's got to be someone in your family or a friend, and someone younger and in better shape too. I'll even ask, when people get witnesses for a will, find me people half your age and in better shape, and who aren't taking anything under the will. That's a tall order, but it really is one of the first things people need to think about. Who is going to be my personal representative? For a will, that person is called an executor or executrix. We still have two different sexes in New York State in that. For the power of attorney, everybody gets called attorney in fact, but who's it going to be? And if that person is unwilling or unable to serve, who's the next person going to be? I like to go 3 deep whenever I can. Give me an alternate and an alternate. Steve is shaking his head back there. You have your will made out, Steve? Am I in it? Okay. For your vast millions.
This is Dying to Bloom. I just wanted to let everyone know the phone lines are open if you do have a question for Attorney Duncan Lee, who is co-host of The Law and You, that airs right here on WRCR on Saturday mornings at 10 a.m. 845-362-0013 is the number. And I also wanted to mention a few websites. The National Healthcare Decisions Day organization has their own website, nhdd.org, and also the National Funeral Consumers Alliance, funerals.org, has some great information in preparing yourself. They have a booklet available called Before I Go, You Should Know, which helps cover pretty much all the areas that you should think about in planning for for the time. It includes wills and as well as financial power of attorney. It really is a booklet that helps you to fill out where family members can find everything they need to know in planning for your funeral, where your will is located, whether you do have a healthcare proxy or that type of thing. Since I was talking about these documents, Duncan, I wanted to know also, is it necessary to go through an attorney when you're filling out these forms, a will, or a healthcare proxy, or an advance directive?
Good question. One I get asked frequently. Do I really need an attorney? The answer I always give is akin to looking at the difference between first aid and brain surgery. If you have a minor cut, scrape, or burn, you're probably fine with just washing it with soap and water or some kind of solution like that, and putting a dry, sterile dressing on it pursuant to American Red Cross first aid procedure, and you're probably going to be just fine and dandy. But for brain surgery, do you really want to pull out the power drill? Probably. So the answer is yes and no. If you are a young couple, a husband and wife, renting an apartment, you don't have two nickels to rub together, then you're fine either doing nothing or getting a very simple will from a place like Nolo Press, where you can fill in the blanks yourself and do it. But the more property you acquire, the more you have at stake, you've got to ask yourself, do you really want to take a lifetime of effort and achievement and entrusted to a do-it-yourself position. You may be absolutely fine doing it that way, but there's so much at risk that it's probably at least wise to have an attorney review whatever you do. And that's a nice in-between phase. So go out, get your do-it-yourself kit, and pay an attorney to look at it and say, does this do what I want it to do? And the attorney will charge you, as he should, and then you'll get some peace of mind. So that's an in-between thing to do. And I think you have a caller, so...
Yes, good morning. You're on Dying to Bloom.
Yes, good morning, Duncan. You were talking about self-done wills. Are there certain ones that are, more legal, or is there some that you can get that, or better?
Well, the only legal requirement for a will is that it be subscribed by the testator and witnessed by 2 witnesses in New York. That's the big legal requirement. Are there companies that make better ones than others?
Well,
I've only seen Nolo presses and Quickens, and both of those are fine, and they can be used as starting points. As I said, if you have very little property, you're a husband and wife, let's say, with no children, and you have no property outside of New York State, no great financial dealings, your estate is worth under $500,000, you might be fine with one of these things.
Right.
But my advice is always the same: at least pay an attorney to look at it when you're done and say, yeah, this will do the trick, or no, you're going to have a problem with this. That's the intermediate grounds. But those 2 companies' wills I've seen, they look fine for very simple things. But again, you have to start by saying, how much is at stake here? This is my life's work, and do I want to risk it?
Right.
It almost is like playing roulette,
right.
And the people who are going to get hurt are the people who are left behind. Now, you also can do nothing. I mean, New York State has a will for you. It's called the Law of Intestate Succession, and that law decides who's going to take. It says if you die without a will and you're a husband and wife with no children, that basically that spouse is going to get everything. But you do have to go through a court proceeding to do that. You have to get what are called letters of administration from the court instead of letters testamentary. So the short answer is, can you do it yourself? Yes. You can represent yourself in courts of law all the way up to the Supreme Court of the United States, if you so desire. But again, what's at stake, and do I want to risk it, are the big questions.
Right. Okay. Thank you very much.
You're welcome.
Thanks for calling, and we do have another caller. Good morning. You're on Dying to Bloom.
Good morning, Duncan.
Good morning.
If I heard you right earlier, you had said that you had preferred wills over trusts, and my thinking was always trust was a better vehicle to dispose of your assets. You don't have the expense of going through court proceedings and have a public display of your assets. So could you just tell me maybe why you're negative about any type of trust for transferring your property?
Sure. And reasonable attorneys disagree on this, too, by the way. I will say this is my opinion. I won't pretend to represent the majority of attorneys, but most estates that I see, I said, are estates that are worth somewhere in the neighborhood of $500,000, where the husband and wife own a house, and that's about it. They also usually have children, and as you know, when you die, those children who get along so well start disputing each other when it comes to the will. One of the things about wills is that are more tightly supervised by the courts. The process known as probate is a continuing process where you first show that the will is genuine and a person is appointed as the personal representative, that is the executor or executrix, and that person is supervised by the courts. In trust, the supervision is missing unless someone takes somebody to court. So that's my first disagreement. The second is, of the things that Congress tinkers around with when changing laws, they tinker around with the trust laws a lot more than they do with the laws involving wills, which are primarily left up to the states, particularly in terms of taxation. The main reason people want trusts is that they're worried that they might enter a nursing home and they don't want their property taken by the nursing home because they want to be on Medicaid. And And so what they're doing is, in effect, Medicaid avoidance. Our Medicaid system is set up so that those who can pay should pay. And a much better deal than the problems you face with trust, because there's a time period where if you transfer your funds to a trust, that's 36 months, that you've got to wait before you're eligible for Medicaid, or you've got to pay Medicaid back. It's a pay down period.
Right.
You're better off buying Medicaid long-term care insurance. The cost of that will be cheaper in the long run for most people than moving everything to a trust. But those are my opinions, and your personal situation you should review with your attorney. That's the only way to make an intelligent decision. My
I'm
giving
just
general
kind of
advice
speaking
isn't
from
going to do it.
experience, because I had gone through the process of a will being transferred, and it was challenged, and the court proceedings, the jury trial, turned out to be quite an expensive ordeal.
It can.
And that's something I wouldn't want to give to somebody else when my will may be challenged, and maybe all the assets are eaten up by attorney's fees.
Well, again, it depends on the will. It depends on your personal circumstances. That's why I recommend, you not make any decision based on what I'm saying right now until you sit down with your own attorney and review it. But a trust doesn't guarantee that there won't be challenges. There would be just as many possibilities of challenging a trust as a will. They're both based on whether the person who made it out, followed the forms required by law, and they're fairly simple, but whether or not the person was under any undue influence or duress, or whether the person was in his right mind, those are generally the basis for will challenges.
So a court proceeding could still take place
absolutely.
even if you have a trust?
Oh, absolutely.
Okay, yeah. I didn't even
So if
consider
you
that.
want to just safeguard against being sued, that's going to depend on the quality of the will drafting and the will of those who want to sue you. Basically, somebody with enough money can hire an attorney to represent him to start a lawsuit on very little, with the hopes that maybe he'll get a settlement or get some blood one way or another. But the best safeguard of that is a well-drawn will. Most attorneys use computer programs to do these days, so most provisions are standard boilerplate, and it's the crafting of the terms to fit your particular circumstance that's where the attorney's skill comes in. So if you are happy with your attorney, you've used him all your life, he's done other things for you, then turn to that attorney first to find out what's the best vehicle for you.
Well, thank you very much.
You're welcome.
Thanks for calling. Wow, some great questions there, Duncan. The number again, 845-362-0013. We just have a little bit of time left, but you still have time to get a phone call in if you do have one for Duncan. Again, this is Dying to Bloom. And that previous caller brought up another topic for me, since he was talking about Medicaid, prepaid funerals, and that could be a whole nother show topic. We'll have to have you back again, Duncan. But I understand that people may want to do a prepaid funeral to spend down their assets, so they do qualify for the Medicaid. But there are scams out there.
Oh, and there are caveats too. A prepaid funeral is just what it says. You go pick out your coffin, you pick out the flowers, you pick out all the funeral arrangements in advance, and then you go ahead and pay for it. And when you die, it's a matter of telling your representative that the instructions are in place, it's already paid for. Go and have the funeral and pick out someone to do the eulogy. You can even do that in advance. The Googly, I think, was one TV show I watched recently, the eulogy. But suppose you have prepaid to a corporation. Now, many of the local funeral parlors have been taken over by big corporations. It's a big industry dying. Mm-hmm. After all, it's one of those constants along with taxes. Mm-hmm. So are you dealing with a hometown person that you know and has been in business for a while, and by the way, is in good health and not likely to retire before you die? Is there some provision in the contract for what happens if the business is sold, goes bankrupt, and so on? Funeral parlors are businesses like anything else, and they can come and go. So just as prepaying for anything, you could do a layaway payment for a car, and then the dealership goes out of business, the car is gone, and everybody's in bankruptcy, and you're not getting your money back. So that can happen too. So yes, tread with care. Are there scams? There's a scam for everything. Somebody will call you up and say, "Hi, I'm from WRCR. We're looking for donations for the show," and it's not anybody from WRCR at all, because we're not allowed to do that, right? As Steve pointed out earlier today. Mm-hmm. So, or the local police department. I had a knock on my door the other night from a woman getting stuff for poor children who were disabled. And she's knocking at my door. She's very trustworthy looking, very nice lady, good presentation. And I said, no, I don't give stuff that way. Mm-hmm. So scams abound. And the best thing to do with this is first give a call to Consumer Protection in Rockland County and ask them if anything's on their radar about the place you're about to go to. Check with the Better Business Bureau. Go online and check out the funeral parlor name. See what reviews they've gotten. People review these like they review everything. I don't know if they appear on TripAdvisor yet, but somebody out there is going to get wise and set up a funeral parlor review. Angie's List, maybe, I don't know. But check them out, and there's no such thing as 100% guarantee on anything. But what you want to do is take reasonable steps, okay? So you can have some peace of mind.
And since we're just about out of time, also just to sum it up, as far as advance directives, there's a lot of thought to put into this. I mean, I've talked about yourself being in this situation, and then, of course, there's a situation of a parent who's gone into the hospital and slips into a coma. Do you know what your mother or father would want as far as decisions go? And
right.
You brought up a good point that the hospitals do tend to ask about that nowadays.
And you can get a free one too if you go to the New York State Bar Association website, nysba.org. You can see a free healthcare proxy form there and a free living will form, which you can use. And until you get to see your own attorney, those are good starting points at least. So you can download them. Again, that's www.nysba.org. And right on the home screen there, it'll tell you where to get the forms for a free healthcare proxy and free living will.
And there's a lot of thought going into who you pick as a healthcare agent for yourself, and whether you're asked to be one for someone else. You have to keep in mind, can you enforce their decisions, even if you don't agree with them? That's
a biggie. Again, the big hard part is picking out those personal representatives. Who is it going to be? Do I trust this person? Am I in a bad seed situation with the person? So, those are big concerns. And once you've surmounted those hurdles, and if you're getting ready to do this, do that first. Get a list of the property that you want specifically given to someone in a will or a trust, and then it's time to go see the attorney. Have everybody's names, addresses, phone numbers all written out before you get there, and that'll make things much easier when you actually do sit down with your attorney.
And I want to give one more time. The National Funeral Consumers Alliance is funerals.org, and the National Healthcare Decisions Day website is nhdd.org. We'll take one quick phone call and then we'll wrap it up. Hi, you're on Dying to Bloom.
Hello, good morning. It was mentioned about if you're worried about Medicaid, that there's some kind of insurance or something you can get.
Well,
can you please elaborate?
Sure, it's not Medicaid insurance. It's insurance for long-term health care. And
that's what you're referring to.
Yeah, go to the official New York State website, nys.gov, and there'll be information on that website about long-term care insurance.
Yeah, that I'm familiar with.
Right, you pay a premium. For most people who are thinking about this, it means you're getting close to that time. And there may not be enough time to deal with the Medicaid pay-down rules. So the insurance is a much better bet. You will spend money on it, and of course the older you are, the more you'll spend. But you also won't have to worry about circumnavigating any laws and what happens if you've messed up.
Got it.
Okay?
Thank you.
Good luck.
Thank you for calling. And Duncan Lee, thank you for coming in this morning. And I don't know if you want to give your office number or if you want me to just remind people to tune in every Saturday at 10 a.m.
Tune in every Saturday. If you'd like to call me, I'm in the phone book. The number is 353-2050. And that's, of course, 845 area code. The name is Duncan Lee, and I'm always happy to have business. But this is primarily a service to the public. So call your own lawyer first. If you need a lawyer and you're not familiar with them, you don't want to call me, that's fine. Give the Rockland County Bar Association a call. They have a list of lawyers in every possible legal area, and they can refer you.
Thank you, and thank you again for coming in. This is Carrie Potter for Dying to Bloom, where we spend time thinking about end-of-life decisions, which is a difficult topic, but for now, you're alive. So let that concept lead you, inspire you, live your life to its fullest, and keep in perspective what's really important. And join me next month on Dying to Bloom.
Soak up the sun.